Good afternoon, everybody. My name is Andrew Zwerling. I'm here with Lauren Levine, Mary Ann Monroy, and Salvatore Puccio. The four of us are partners at Garfunkel Wild PC, and we'll be your hosts today at today's webinar, Navigating a Murky Landscape, an Employer's Guide to Responding to the Challenges of COVID-19. By way of introduction, the outbreak of the COVID-19 virus has confronted all employers with unprecedented challenges in maintaining workplaces and operational viability. And with ever-increasing speed, new laws are being enacted by the federal and local governments that are designed to soften the economic and health and safety impacts posed by the virus, but which also, no matter how well-intentioned the legislatures, have created a certain amount of confusion about available feasible options for employers on how to move forward in sensible, compliant, and practicable fashion. By way of examples of the ever-changing landscape, just this weekend there was more guidance issued by the United States Department of Labor on the how you interpret some of the federal laws that just came out, guidance that we have incorporated into today's program. Another example that stands high on the radar screen is the stimulus bill, which our firm is analyzing. We'll address the stimulus bill in this program. I should also let you know that our firm will be conducting a standalone webinar coming up shortly concerning the stimulus bill, and a notice will be sent out about that. As far as the purpose of today's webinar, it's to try and dissipate, if not eliminate, confusion concerning these recent legal developments. And among the topics we'll cover in this program include highlights of the federal leave laws, the recent emergency laws, I'll call it that, highlights of the updated New York State leave laws. For example, what is the type of order that triggers an employee's entitlement to leave under the new statutes? Who is a health care provider? We'll talk about the tax credit issues, the stimulus bill. Most importantly, go over practical considerations on dealing with these challenges. Because there are a number of listeners who may not be familiar with our firm, a brief introduction is in order. Mary Ann, Lauren, Sal, and myself, we are partners in Garfunkel Wild's litigation and employment law practice groups. Garfunkel Wild is a full-service law firm with more than 85 attorneys serving clients in New York, New Jersey, and Connecticut. It was founded nearly 40 years ago with an initial mission of attending to the specific business and legal needs of the healthcare industry, but over time has evolved and now represents clients across a rather diverse spectrum of industries. We provide legal advice to clients covering a wide range of service areas, including healthcare, compliance, corporate, finance, real estate, healthcare, information, and technology. And pertinent to today's program, our firm has a robust employment law practice group that attends to our client needs in New York, New Jersey, and Connecticut. Our practice group provides advice on a full range of employment matters. We give day-to-day counseling, but we also have decades of litigation experience. Mary Ann, Sal, Lauren, and I, along with our other colleagues in the employment law practice group, wear two hats, which gives us a unique and pragmatic perspective as employment lawyers. We litigate and try cases, so we see where clients handle things right or where they handle things wrong, and we use that information to inform our day-to-day counseling. And we're using those two hats in putting together today's program in advising you and helping you navigate this very difficult landscape. Not only telling you what's going on the ground, but hopefully to assist you in anticipating problems that may arise down the road. Two very quick logistical issues with regard to questions you may have. You can write them to us, and we'll do our best to answer them during the program. Please recognize, however, that there's a lot of material to cover in this session, and we may not get a chance to answer all questions that are posed to us. As true with other webinars our firm has conducted concerning coronavirus issues, if you have further questions that we weren't able to answer or in need of assistance, please email either Lauren, Mary Ann, Sal, or myself, alternate dates and times in half-hour blocks when you're available to speak by telephone, and we'll set up appointments to help you walk through the issues. Given the intensity of the calls we've been receiving in the last 2 weeks, we'll set up appointments with existing clients first. If you're not a client of the firm, don't worry. We'll take care of the necessary documentation to fix that issue and set up time for you as well. Secondly, from a logistical standpoint, and as a reminder, a recording and a copy of the slides will be sent out by tomorrow. So without further ado, we'll proceed to the subject matter.
All right, good afternoon, everybody. My name is Mary Ann Monroy. I will be tackling the first section of our program regarding the Families First Coronavirus Response Act. So that's the federal piece of legislation. It has basically three main components. It has a paid sick leave component, and that's for paid leave related to COVID reasons. It has an emergency family leave act component, and that's an expansion of an existing federal law, the Family Medical Leave Act. So it's extending the reasons that you can take FMLA leave under this act, and it extends the coverage of employees who would be qualified to take this expanded FMLA leave. It does not extend the length of FMLA leave. So for instance, if those of you who are familiar with FMLA leave, it's usually just 12 weeks of leave. That still remains intact. The other thing with this new leave law, it is not retroactive. So it will take effect on April 1st, and we'll talk about that in the next slide. If you already gave individuals some sick leave prior to the enactment of the start of this new law, you don't get an offset or a credit. It's not retroactive, and you can't deny people leave next week because you gave them leave the week before. I see someone who already put in a question about, if my firm or the company already has a sick leave policy where they earn 1 day per month, do they have to provide this? And yes, they will have to provide this on top of the leave that is already that they already provide pursuant to their policies. All right, so I'm going to move on to some of the text of the law. We're going to just flip slides here. So as I said before, it starts as of April 1st. Interestingly, the law was signed on 3/18. It was supposed to take effect in 15 days. Should have been April 2nd, but the DOL guidance actually says it takes effect on April 1st. So we're going to go with that. These laws will remain in effect, and they can use these benefits through December 31st of this year, unless it's further extended. So we don't know if that might happen in the future. This paid leave benefit is for COVID-related reasons, and we'll go over those in more detail on the next slide. But I want to start off with, it applies to employers with fewer than 500 employees, okay? So you should know who you are if you're 500 employees or less. You're going to take into account full-timers, part-timers, temporary employees. If there is a joint employment relationship, maybe you have a business that's or a joint employment type of relationship with an affiliated entity, those employees with the two entities would count towards that calculation. And you would do a similar test that's used or applied when you're applying the Fair Labor Standards Act. So if the entity has similar management or common ownership, all of those employees would count together in counting up whether or not you hit the 500 or fewer. All right. Another important piece of this law is that an employer who has a healthcare provider, an employer of an employee who is a healthcare provider or an emergency responder, may elect to exclude such an employee from having this benefit. Now, I guess the idea behind this is that we want the healthcare providers actually working, and not necessarily taking time off for the paid leave under this section of the law or the family medical leave section. The Department of Labor guidance says they really want you to use this judiciously if you're going to exclude somebody. So someone who is really sick, you might want to give it second thought. But who is a healthcare provider or an emergency responder has been a big question that remained unanswered until just this past week, and actually Friday night, some guidance came down on who is an emergency responder or a healthcare provider. Initially, there was some thought that it might just be the doctors and maybe PAs and possibly nurse practitioners, but really it's a very broad definition. We have a slide at the back of the presentation so that if you print off a copy, you'll see that definition out there. But it's anyone who may be employed at a healthcare facility, such as a doctor's office, a clinic, a hospital, a pharmacy, for example. Anyone who works at those types of organizations or entities could potentially be excluded from this federal benefit, okay? And as far as emergency responders, it's those who might be involved in the transport, comfort, nutrition of a patient, or those involved with limiting the spread of the virus. Interesting, the guidance also talks about if you are an entity that contracts with a healthcare provider, the employees of that entity may also be excluded. So if you're an entity that produces medical equipment or drugs or involved with diagnostic vehicles, there may be an exclusion as well under that provision, all right? As I said before, you're counting full-time and part-time employees. I believe I didn't mention that full-time employees are those who work 40 plus hours. Part-timers are those who work less than 40 hours. Businesses with less than 50 employees can request an exemption when the imposition of the requirement would jeopardize the viability of the business, okay? So again, it's only going to apply to the smaller businesses potentially who can then claim certain criteria that it would be such a hardship for them to have to pay this benefit out. And some of the things that they're going to have to establish is that the provision of providing the paid sick leave would result in a situation where the business's expenses would exceed available revenue and make it impossible for the business to continue operations, or close to impossible. Another thing would be if the absence of the employees who are requesting the leave would curtail the ability of the entity to actually perform their business, okay? And that would apply largely to some of your key employees, that without them actually coming to work and performing their job, you couldn't provide the service or function as a business. And then the other hardship criteria involved in getting an exemption is if everybody went out on this type of leave, can you establish that there would not be sufficient workers able, willing, and qualified to perform the job, okay? So it would be fact specific, but it's something to keep in mind, and you would have to apply for that type of an exemption. All right, now moving on to the next slide here. So there's eligibility criteria, obviously, for employees to request this type of leave. Now, there is no waiting period for this particular benefit. Unlike the family and medical leave benefit, there is like a 30-day waiting period. Here, if you're working, you're employed, you can apply for this paid sick leave benefit. So what are some of the reasons you can take it? So one of the reasons would be if you are unable to work or telework, and we're talking about the actual employee, because the employee is subject to an order of quarantine, whether it's state or local, related to the coronavirus, all right? Or they've been advised by a healthcare provider to self-quarantine due to the concerns related to coronavirus, or they're experiencing symptoms of coronavirus and seeking medical diagnosis. So obviously that's a very broad criteria for the employee themselves to request the leave, all right? And a doctor's note or something to that regard is going to likely suffice to qualify them. Now, if they can telecommute or work from home, then this paid sick leave benefit does not need to be granted. So it's those who can't work from home because of these particular reasons. Now, for full-time employees, they can get up to 2 weeks or 80 hours of paid sick leave. Now, that's going to be at their regular rate of pay, or no less than the federal and state minimum wage. There is a cap under the regulations of $511 per day, or $510 total for the entire period. Now, that's for your full-time employees. For the part-time employees, you have to do a calculation. So essentially, it is prorated. The part-timers are not going to be entitled to the entire 80 hours. So if, for example, you have a set schedule of 3 days per week, 8 hours a day, 24 hours a week, 2 weeks would be 48 hours of paid sick leave. I mean, that's a simple example. When you get into scenarios where an employee has a variable work week, and then you have to do a form of averaging over a 6-month period. If they haven't worked there for 6 months, you're going to average the amount of time that they have worked for you from the date of hire, okay? Now, another thing that's come up before where people ask, well, if their schedule was reduced to part-time as part of a reduction in force, all right, can they use this paid sick leave to make them whole or make up the deficit? That they can't do. So if they are currently now switched from full-time to part-time and they work 3 days a week, they can't say, well, I would like to take 2 days of paid sick leave to make it whole, all right? Okay, so I'm going to move on to the next slide. All right, some other eligibility or reasons for using paid sick leave. So it could also be used by an employee who has to take care of an individual who is subject to a quarantine order for coronavirus, okay? And again, that assumes they can't telecommute or work from home. Or if they have to care for a son or daughter because the school or place of care is closed, that would also give rise to using some of the paid sick leave. Now, I had a question over the last week or so, and the guidance recently came out about what if you have an adult child who has certain conditions like a mental disability or physical disability, would they be covered? And the guidance recently that came out said they would be covered under this. So if you have an adult child over the age of 18 with a mental or physical disability and they're incapable of self-care, you can apply for that paid sick leave benefit to care for that child due to maybe a closure of an adult daycare. All right. Now, what is the extent of the benefit for this type of paid sick leave? So for the employee's own health condition or quarantine, they're going to get their regular rate of pay. But if the employee is taking care of someone else, or they're caring for a child because a school or a daycare is closed, they're going to get up to 80 hours, but at 2/3 pay, capped at $200 a day or $2,000 in the aggregate, okay? So you're not going to get the full regular rate under this provision or for this usage. Same applies for the part-timers. You're going to look at the prorated amount of hours they normally work in a week. So in that prior example, if the person generally works 3 days a week, they get 48 hours of sick leave, but it's going to be prorated at 2/3 their rate, okay, up to that cap of $200 a day and $2,000 in the aggregate, all right? Okay, so we're going to move on to the next slide here. Does the emergency paid sick leave replace existing leave? No, it definitely does not replace existing leave. This is above and beyond. So if you provide New York City sick leave or New Jersey sick leave or Westchester County has a sick leave law, those are all in addition to, okay? And importantly, you cannot require your employees to exhaust their existing leave banks before using emergency paid sick leave, okay? They get to use this first. If they run out, they can choose then to use their other sick leave, all right? And there is no carryover, so you can't carry over from December at the end of the year, flip it over to the next year. If you don't need the sick leave, it's forfeited at the end of the period. There's also some guidance on intermittent use of sick leave, so that might be available as well. So if you're a full-time employee and you do work 5 days a week, but maybe you need to take care of a child 2 days a week for the first week, you could, if your employer agrees, right, there has to be a mutual agreement for it to be intermittent, you might be able to use 2 days of your schedule for sick leave and then work the other 3 days. Your health benefits are going to remain intact. You only get this benefit or this 80 hours one time. So if you use it all up to self-quarantine, you don't get another 80 hours because you need to care for a child that's home for because the school is closed. That doesn't mean you don't get the family leave benefit, but I'm just saying you can't get double of the paid sick leave for different reasons. All right, next slide. So the next portion I wanted to talk about is the component of the federal law that deals with an extension of the Family and Medical Leave Act. So FMLA leave is, has been in the books for many years now for a variety of different reasons, like bonding with the child and other illness related. But this is an extension that specifically applies to coronavirus, and it doesn't add to the total of 12 weeks that you get under typical family and medical leave. So if someone happened to have used 4 weeks of medical leave already, they have another 8 weeks left to potentially use an expanded piece. Okay. Again, it applies to only employers with 500 employees. The Department of Labor has enacted some exclusions, as they did with the sick leave component, where healthcare providers and first responders may be exempted from this family leave benefit. So again, if your staff at a doctor's office, they may be exempted if the employer decides to do so. Okay, I'm going to flip over to the next slide. All right, so eligibility requirements. Typical FMLA leave, which usually applies to employers with over 50 employees. So here that doesn't matter. Anyone with less than 500 employees would be eligible for this. So if you only have a couple of employees, you can apply. This would be applicable to you. And the employees themselves only have to have been employed for 30 calendar days. All right. Under usual FMLA thresholds, it's 1 year, 1,250 hours. And for other standard FMLA-related reasons, those still apply. So someone who's going to go out for the birth of a child still would have to show they worked for 1 year, 1,250 hours. But if they want to use this for the reasons set forth in this particular piece of legislation, it's only 30 days that they need to have worked for the employer. Okay. So this piece allows you to take time off if you're unable to work or telecommute or telework because you have to care for a son or a daughter under the age of 18 because the school is closed, daycare provider is closed, that type of thing. Again, if you have an adult child with a mental or physical disability, that could apply as well. All right, next. The benefit allows for up to 12 weeks of leave for the coronavirus reasons, okay, related to taking care of a child because the school is closed. The first 2 weeks, 12 weeks, however, is unpaid, all right? But what an employee can do is apply to use the sick leave portion for those first 2 weeks, okay? And then use the remaining 10 weeks. They are going to get at 2/3 their regular rate of pay, up to $200 per day, $10,000 in the average. But really, in reality, if they apply the 80 hours, right, from the sick leave to that 12-week period, ultimately they'll get the ability to have potentially up to $12,000 aggregate. All right. Now, as far as job protection, similar to the Family and Medical Leave Act for the other reasons under the standard FMLA laws, you're supposed to be returned at the end of your leave to the same or equivalent position, You cannot fire or discipline someone because they took the leave or they made a complaint about taking the leave. But under this law, it doesn't protect employees necessarily from layoffs that would have happened anyway. So if an employer was going to lay off employees because of the financial impact, they wouldn't necessarily be precluded from being laid off because they were on this leave. There's also a provision in there that if you're a small employer, 25 employees or less, that you may be able to claim a hardship exemption so that if the position no longer exists, you wouldn't necessarily have to put them back into that position if the economic conditions make it unsustainable. And you would also have to show that reasonable efforts were made to restore the employee, and you made reasonable efforts to contact the employee if an equivalent position comes up, and you'd continue to have to make those reasonable efforts for a 1-year period. All right. So that's basically, in a nutshell, the provisions of the sick leave component and the family leave component. So
on what documentation may be required from an employee claiming a leave benefit. There's no guidance as to what proof or documentation an employee must provide an employer in order to be entitled to leave benefits, or whether an employer can insist on the production of such documentation before paying the leave benefit. Our view here is that common sense and pragmatism should be the guiding principles. So, for example, school closings are easily verifiable online. The closing of New York City schools is just an example. In our view, it would make little sense to demand in rigid fashion that parents of minor school-age dependents provide notes from school administrators to be entitled to a leave benefit. On the other hand, if someone's claiming that they or their family member is subject to an order of quarantine or isolation, we submit it's reasonable to demand a copy of that order, which order may be readily available for production either in paper or electronic form. If you face a situation where an employee claims that there's a backlog in obtaining a copy of the order, and that might be true, there may be such a backlog, then ask for documentation from a licensed medical provider who's treated the employee, attesting that he or she qualifies for the order. As for clinical grounds for a leave benefit, we feel that the same documentation to which an employer would be entitled under FMLA may be requested in this context. And as you may be aware, under FMLA, an employee may require that a serious health condition or serious illness or injury of a covered service member be supported by a certification from the employee's health care provider or an authorized health care provider attesting to those facts. There may very well be instances where you're uncertain how to proceed. That's just the nature of the landscape that everyone's facing. But with regard to the issue of documentation and in responding to those situations, please keep in mind that it may prove less costly and impactful to pay the benefit today and recover it down the line if you learn that someone was wrongfully paid the leave benefit than bear the burden of costly penalties associated with a wrongful denial of leave benefits. Again, just a practical point to help you handle these situations as they may arise. All right, next slide up deals with the notice and posting requirements. All employers have to post in a conspicuous place on its premises a notice of these new requirements. We put on this slide where you can access a copy of that poster, a couple of practical points associated with the notice and post requirement. At this juncture, a lot of people with the stay at home or work at home orders are asking, well, where do I post a notice for my employees who are teleworking? For those employees, you can email the notice to them, or post a notice on an employee information internal or external website. As far as the language the notice should be in, at this juncture it could be English, but the Department of Labor is currently working to translate it into other languages as well. As far as who gets the notice, recently laid off individuals are not entitled to the notice. Prospective employees are not entitled to the notice. New hires, on the other hand, must receive that notice. And again, you can do that by email, or posting it in the manner that we just described. This requirement applies to everyone, including small business owners. All employers covered by the paid sick leave and expanded family and medical leave provisions are required to post this notice. As far as the location and how you define what constitutes a conspicuous place, for the most part, employers know, where the main sites are in their workplace. If, you have employees who come in and use a particular break room, a particular lunch area, or must report to the main office headquarters, and there are common sites on that premises that they frequent, then the notice can be placed there. On the other hand, if you're an employer who has many buildings and people report to their separate buildings directly, then you would be required to post a notice in each one of those particular locations to ensure that the notice is provided to those employees. You can't put them in a binder. You can't put them in the employee policies binder. Again, they have to be posted in a conspicuous place that's accessible, either electronically or otherwise.
I just, before we move on, Sal, just 2 or 3 quick questions I just wanted to answer because they came up repeatedly. So if your business closed with regard to the federal paid sick leave, if you're closed or you furlough people, they don't get the paid sick leave benefit. They can get unemployment. If you switch them to part-time the last week or so because of what's going on, they get the part-time equivalent. So if they used to be full-time, but now they're part-time, they're going to get the part-time equivalent of the 80 hours of paid sick leave. And if you gave them prior to 4/1, it doesn't count towards the benefit allotments that are going to go into effect on Wednesday. Okay, so I'm done.
Okay, thank you. This is Sal speaking now. Turning to one of the questions that we got early on, which was a very, very big deal for employers, which is, who's paying for all this? This is a lot of money. Where is it coming from? The short answer is you, as the employer, are required to pay for the leave under both the sick leave and the federal extended family leave that Mary just talked about. That said, there are tax credits that are provided in the bill, in the law, and there is guidance that finally came out after a few days of everybody going back and forth to figure out, well, how do I get my tax credit? It was communicated through IRS guidelines that tax credits will be received on a quarterly basis based upon your payroll taxes. These examples that we have listed here on slide 13 are directly from that IRS guidelines, and basically they demonstrate that if you're an eligible employer, pays $5,000 in sick leave and is otherwise required to deposit $8,000 in payroll taxes, including taxes withheld from all of its employees, the employer could use up to $5,000 of the $8,000 in payroll taxes as an offset. And that's how you'd get back that money. The employer would then owe the balance of $3,000 on payroll taxes. We did receive some questions as follow-up that, well, what if my payroll taxes don't hit the allotment that I have to pay out for sick leave or extended leave? And the IRS also answered that to say that they'll make up the difference. So if you see the example here, sick leave is $10,000, but you have only $8,000 in taxes. Where do you get the balance of $2,000 from? You can make an application to have that amount accelerated as a tax credit as well. So that becomes more of a refund. They look at it as a credit. So those are just some factors to keep in mind with respect to the taxes. The idea here is for employers to be made whole at 100% of the money that they lay out for the provisions that Marianne just spoke about in terms of sick leave and emergency federal leave. Also, there are offsets against maintaining health insurance. So in terms of your record keeping, work with your payroll companies, work with your accountants to make sure that you maintain records of anything you're paying for sick leave, documented carefully, as Andrew was saying, as well as anything you pay to maintain health insurance as well. Some issues related to enforcement of these requirements. The first piece here, this is very helpful, and we're glad to see that the Department of Labor came out and issued guidance confirming that these requirements, there's going to be a 30-day non-enforcement period. So basically, If within 30 days it's determined you did something wrong, or an employee complains, or you later find out you handled something inappropriately or improper, you can correct it without penalty. That said, it's good faith compliance efforts. So if you know something and you're just trying to be cute or trying to get around a particular provision and there is an investigation, then there will not be this delayed enforcement. However, if it's in good faith, and we like to believe everybody's operating in good faith in these very difficult times, there's a bit of a grace period. But if you do violate something and it's after the 30 days or you're found to be willful, well, the penalties that would apply normally under the FLSA and FMLA would be triggered. One point I do want to note here, the FLSA penalties are rather extreme generally. It includes liquidated damages and attorney's fees. So that's where you can get very costly. So certainly not worth trying to skip one day's pay, capped at whether it's $200 or $511, when the back end is going to be much more costly. The other thing with liability under the FLSA is there's the potential for individual liability. So that's just something to keep in mind. A few prohibitions that I'm going to go through just very quickly because Marianne touched on most of them. You can't discharge, discipline, or otherwise discriminate against an employee who takes leave under the federal law. That should go without saying, but of course it's in the regulations and follow-up guidance from Department of Labor. You also cannot force an employee to use a paid leave provided by the employer prior to using the sick leave. As Marianne noted, we saw a lot of questions on that. And modifying your policies to defray or avoid these costs of emergency sick leave is also prohibited. And again, that goes more towards when the laws take effect. Again, you have to keep in mind, we understand that the landscape is changing on a daily basis, and sometimes it feels like hourly. So while you might have someone employed now that's receiving these benefits, if the business is forced to close in a few weeks because of other business concerns, financial constraints, reevaluate at that time. The law might have changed. There might be opportunities for you to lay somebody off, allow them to collect unemployment without running afoul of any of these laws, because we do understand it is going to be a financial burden to lay out the cost for a lot of these provisions and then have to wait 3 months or some shorter period of time in order to get a tax credit. And we'll talk a little bit more about those scenarios on the back end. So now I think we're going to turn it over to the specific state law provisions and Lauren Levine.
Yes, hi, good afternoon. This is Lauren Levine. I'm going to be talking a little bit about the New York State paid sick leave, which is much narrower than the federal rules you just heard about. On March 19th, Governor Cuomo signed this bill for paid sick leave. We're going to focus today on the COVID provisions, but you should know as employers that they did add a general sick leave benefit, which will take effect later this year, and will be available to talk about that at a later date. But currently, the New York State paid sick leave related to COVID is really limited to an employee who is subject to a mandatory or precautionary order of quarantine or isolation that's issued by the state, Department of Health, local board of health, or any other government entity that's authorized to issue such an order. We should also mention that this covers if your minor child is subject to a mandatory or precautionary order and you are required to stay home to care for them. So it's an order that applies to you as the employee or to your child. We've been getting a lot of questions about what proof is required to show that an employee is subject to one of these orders. Now, as Andrew mentioned earlier when he was talking about the federal law, for this provision, technically the employee is supposed to provide the order that they are subject to. However, the Department of Labor has already recognized that there is a backlog in requesting those orders and has said that it is an interim measure. An employer should accept a physician's note that indicates the employee is subject to such an order. And the Department of Labor specifically is talking about, individuals who have tested positive, have traveled to a level 2, 3, or 4 health notice country, or have been exposed to the illness. And the Department of Health is required, the local Board of Health and the Department of Health are required within 30 days of a request to issue an order to the employee who's covered. But again, in the meantime, you should accept a physician's note if that physician can attest that they meet one of the standards. Now, we've also been getting a lot of questions about whether Governor Cuomo's executive orders requiring closure of business or work from home, whether those constitute the type of order that this contemplates. And the guidance out there is that those do not constitute the type of order that we're talking about. The work from home and the closure of business are really not the orders that are being contemplated here. And we'll talk more about why also those wouldn't necessarily apply. But one question we're getting a lot of, and I'm sure you're all getting this question from staff, is whether a school closing constitutes an order, right? We all know that the governor has closed schools. The Department of Labor basically has said if your school was closed because of an actual quarantine, then you may qualify. But if it was closed for social distancing precautions, then likely you're not going to qualify under this provision. Otherwise, they would have included in this act that you're entitled to take time off to stay home with a school-aged child. There is interim containment guidance from the New York State Department of Health that talks about the kind of illness or situations that are really contemplated by these orders. And again, those are where someone's been in contact or traveled to a country with a known risk or has tested positive. Next slide. So as I'm sure many of you are aware, there are different categories of how much time paid employees will receive depending on who they work for. So you can see here there's a couple of different categories. Employers with 10 or few employers as of January 1st, 2020, whose net income of the company was less than $1 million, will have to provide unpaid sick leave for the until the termination of the mandatory precautionary order. And right, we're all seeing those are about 14 days. So it would be unpaid leave for those employees who work for that particular category of employers. During that time, however, the state has expanded the definitions for disability and paid family leave, and those individuals can also apply to be paid under those laws during that time. Then there's the next category, which is employers with 10 or fewer employees who made over $1 million or had net income of over $1 million in the previous tax year, or employers with between 11 and 99 employees as of January 1st. Now, for those people, again, it's 14 days, or the time of the quarantine is how much time you have to give them off, but the amount of paid leave under this category is 5 days. And that 5 days comes out of the employer's pocket. They don't have to apply to the state. They just have to request it from their employer. After those 5 days, for the remainder of the quarantine, those employees can then collect disability and paid family leave. The last category is employees with 100 or more employees as of January. Those employees get 14 days of paid sick leave. So that's all coming out of the employer's pocket where you fall into that category. We've been getting a lot of questions also as to what is the definition of days. The state has clarified that it means calendar days. And what that means is let's say you have someone who's entitled to the 14 days, they're entitled to be paid for the number of days they would have worked in that 14-day period. It does not mean that you automatically give the person 14 days paid. It's the number of days and the pay that they would have made during that time period. Next slide. So there are some exceptions, and they're significant. This act does not apply in cases where the employee is deemed asymptomatic or not yet been diagnosed and is physically able to work by remote or other means. And that's another reason why we do not believe that the work from home order would be applicable here, because if you're physically able to work by remote access or other means, you're not entitled to this leave. Also, if your business is closed, the employees immediately can collect unemployment if the business is closed for a COVID-related reason. In that circumstance, they would be entitled to the unemployment benefit, but not to this sick leave benefit. Another exception I want to mention before I move on is that if an employee is subject to a quarantine order because they traveled to a place with a level 2, 3, or 4 travel notice, and they knew about this provision, they do not get paid sick leave under this act. They would be eligible for unpaid leave for the period of the quarantine, or they could use their PTO, but they will not be eligible to get this extra paid benefit either from their employer or through the state for paid family leave or disability. Now, if an employee is eligible for both the federal benefits that we talked about earlier and the state benefits, they don't get both. They can't stack them. However, if an employee would have been entitled to more under the state act, they get the difference. They get the better benefit. So, for instance, if you were entitled to 14 days paid at full, and that's more than you would have gotten under the federal act, you get the difference between those two so that you're made whole under the state act. Next slide. These are just some generally applicable rules under this new New York sick leave. You cannot force an employee to use their accrued leave. This is separate and apart from any accruals that they have, just like under the federal. So this is time in addition to whatever they may already have in their bank. Similarly, upon returning to work, they must be restored to their prior position at the same pay and other terms and conditions. And there's an anti-retaliation and anti-discrimination provision. I mentioned earlier that for any unpaid time, an employee may be able to collect disability or paid family leave benefits. And this slide just explains that those acts have been updated to include these circumstances for the time being, and there will be no waiting period if the employee applies for disability and or paid family leave under this act, and they can collect both concurrently during this period. There's a maximum benefit of a little over $840 under the paid family leave and a little bit over $2,000 under the disability. So there is a cap, but the employees can collect immediately and concurrently under those two acts. Next slide. I think this is back to Andrew.
With regard to Connecticut, as you can see, the benefits under the Connecticut Paid Sick Leave and Connecticut Family and Medical Leave Act may apply if eligibility criteria are satisfied. So with Connecticut paid sick leave, certain employees are entitled to up to 40 hours of paid sick leave per year related to their or their family's illness, injury, or health conditions. And that leave law applies to most employers who have more than 50 employees in Connecticut. As it relates to COVID-19, and according to a release issued by Governor Lamont on March 24th, the paid sick leave will cover certain absences caused by COVID-19. You know, again, it's going to depend upon the facts of the particular case as it relates to the eligibility criteria under Connecticut's paid sick leave law. With regard to Connecticut's FMLA law, that provides up to 16 weeks of unpaid leave during a 24-month period. There are eligibility requirements there that require that the employee have worked for the employer for at least 1 year and worked at least 1,000 hours for the employer during the 12 months preceding the first day of leave. And that, unlike the paid sick leave, applies to employers who have at least 75 employees in Connecticut. And that's designed, that particular FMLA law is designed to protect those employees who have a, quote, serious health condition, unquote, or who are caring for a family member who suffers from a serious health condition. As that leave law applies to COVID-19, again, according to a release issued by Governor Lamont, Connecticut's FMLA may protect the job of an employee who is sent home for having a fever or because the employee's child is exhibiting symptoms of COVID-19, provided that the employee is otherwise eligible and has remaining leave time under Connecticut's FMLA. A big issue in Connecticut has to do with the manner in which the state is encouraging people to apply for unemployment. If an employer requires its employees to stay at home due to COVID-19, it should issue an unemployment separation package that's available on the Connecticut Department of Labor website. You can find that information readily available there. The Connecticut Department of Labor is encouraging people to apply for unemployment benefits. Again, in the normal course, they're going to make case-by-case determinations. When a business is forced to shut down for a couple of weeks because an employee tests positive for COVID-19, the other employees are likely to be eligible for unemployment benefits under those particular circumstances. So the real philosophy there is to put in the applications and make the case in the normal course under the leave laws or under the unemployment insurance laws, and then the assessments will be made. Next slide, please.
Okay, this is Lauren again. We're talking now about the New Jersey rules. I'm going to fly through this fairly quickly because I see we're running out of time. There are no new laws pertaining to COVID specifically under New Jersey. The New Jersey Department of Labor and Workforce Development, though, has prepared this very handy chart, and you'll see there's a link to it at the bottom there that talks about when you can take certain time off under the leave laws or unemployment, temporary disability, when you can take off time with absences related to COVID. I just want to mention there is one assembly bill that prohibits employers from terminating employees or penalizing them if they request to take time off from work due to infectious disease, including COVID. So that's another thing to be aware of in terms of anti-retaliation. Next slide. These examples are all from that chart of when you can take off sick leave time under New Jersey rules. I just want to point out two of them. The employer stays open in defiance of a public health urging to close and the worker refuses to work, or the worker is afraid of gathering in a group and refuses to go to work and is merely self-distancing. Those two are really more broad than the ones we've seen under the other state laws or federal laws, so I wanted to make you aware of that. And the unemployment insurance will be available if the employer voluntarily closed, was ordered to close, or if your employee is getting less hours due to the business slowdown, they may be able to collect unemployment for that part-time reduction. Next slide.
Okay, we're shifting gears now onto the stimulus bill, or the CARES Act, Coronavirus Aid, Relief, and Economic Security Act. The general background here is this is to incentivize the retention of employees. And as Andrew said at the outset, we're developing further guidance and information related to this specific topic. We do understand it's a hot button topic. Everyone wants to know, what should I do with respect to these loans? Will I qualify? And the big question is, will they be forgiven under the Paycheck Prevention Program that's in place? So we're coming out with further guidance and expect to hold a further webinar just on that topic, hopefully in the next week or so. Just some general information and guidance that we have at the moment, and this is changing really in an hourly sense. The CARES Act is intended to provide various forms of relief, including emergency grants, forgivable small business loans, refundable tax credits, and other incentives to the employers. Basically, you can have certain businesses will qualify for the loans, and it's intended to fund payroll support, sick, medical and family leave, health care benefits, interest on your mortgage obligations, and these were big helpings for our clients, rent and utilities and other limited expenses that can all qualify. One of the threshold questions we are getting is, well, where do I go for this loan? And that's going to be in your local community banks. So we suggest you go to whoever your lending provider is, whatever financial institution you currently work with, and speak to them about their policies and setting up the loans. Or who's going to be eligible? There's a lot of talk about small businesses and also other business concerns that are referenced. Generally, if you're going to be under 500 employees, you should qualify, but this is all going to be industry specific. If you're a leader, so to speak, in particular industries, it might be slightly different. Also, some employers who are larger than 500 but have certain net revenues may qualify as well. In particular, we see a lot of information there coming out regarding the definitions of small businesses in the healthcare community. Offices and physicians, for example, might need it if the standard is less than $12 million in a year of annual receipts, and there are some other guidance as well. The next question that comes is, well, how much can I get? What loan amount will I be able to receive? There are two formulas that are used. It's either $10 million or the product of the average monthly payment for payroll costs incurred for 1 year period before the loan date multiplied by 2.5. So the way we're looking at it is it's an amount that should get you to up to 10 weeks, 8 to 10 weeks of payroll. What are the loans supposed to be for? Again, I mentioned earlier with respect to payroll costs. And related to that, this really is the million-dollar question related to this particular program and this bill is, what about loan forgiveness? Am I going to get this loan forgiven? And the answer is very possibly if you qualify. Right now, the way it's worded, forgiveness would be equal to an amount paid during 8 weeks after your loan originates, up to 100% of the principal. Okay, they are excluding interest. And I should mention that we are seeing that the interest is capped at 4% on these loans, but the principal up to 100% of which will be refunded or forgiven, I should say, applies to payroll, interest on your normal indebtedness, so you can't prepay pre-existing loans, your rent, and your utilities. So those would be the main costs, again, that they're looking for in order for you to incentivize retaining your current workforce. There are a couple things I should mention with respect to reductions in that forgiveness. The forgiveness is reduced by layoffs and salary reduction. So it's going to be important for you to consult with us and or your accountants and the lending institutions because those rules are in place. For example, if wages are reduced by 25%, that could be a factor in the amount of forgiveness that you get back. There's also a provision relating to earners of more than $100,000. We're still waiting for further clarification as to whether that means an earner of $100,000 is excluded altogether from the forgiveness or just their salary over $100,000 being excluded from that amount. And lastly, as it relates to the reductions, there is a provision in the law that allows you to rehire or increase the pay back to normal or the usual rate of pay to eliminate those reductions. So you're going to have to do an analysis, and I cannot generalize this too much because it will be a unique individual inquiry that you have to determine, well, when would be the best time for me to put staff back on if I'm going to take out a loan, and when will be the best time for me to increase any salary reductions or undo any salary reductions that I may have done. And the last point I'll make with respect to this law, the stimulus law and the CARES Act, is that there is a general deferment period of up to 6 months that you can count on. Now, moving forward as we get into the next few topics here, this next slide obviously ties right into the topic of what should I do with the stimulus bill, layoffs, payroll reductions, and furloughs. All of those factors we just mentioned that I just spoke about regarding the loans are going to be a consideration. And it's going to be, again, an individualized inquiry that your business has to make. We understand fully that some folks just cannot make payroll, cannot expect to make payroll on a going forward basis. We've had calls as recently as this morning where clients were calling us up and saying, I'm going to have to close, so the stimulus bill does not help me. Over the past 2 weeks, we've received numerous calls from people saying, I can't make payroll, I'm not going to be able to survive. I was already on the fringes. For example, we represent a lot of hospitality clients, construction clients, and some folks had said the business wasn't great to begin with. Should I wait and see what happens with these different bills and the stimulus package? And again, when you take a hard look internally, you might realize that that's not the best option for yourself or your employees because the employees can go out and then seek benefits under unemployment. Unemployment has also been extended by the CARES Act, an additional $600 per person, which we can talk about a little bit at the end. So there are various things to consider right now for employers. We understand it's a lot. We're going to be there for you as much as we can to help you answer these questions. And now we'll get into a little bit further about some of the topics in considerations here. Layoffs. Unemployment is at an all-time high. It's continuing to go up right now on a daily basis. If you lay off an employee or you furlough an employee, they would be eligible for unemployment insurance. One of the disadvantages of a layoff is that the employee may then have to bear their own health care costs if they are on a health care plan or meet their actual share. If you turn over to COBRA, generally employees are required for the entire amount of the COBRA premium. Mechanically, with respect to layoffs, few things to keep in mind. If you're going to terminate a person's employment, you're going to have to provide them a record of employment form so they can claim unemployment. They would have to get a formal termination notice explaining that their position has been terminated. They would have to get their paycheck on the next scheduled payday in New York. For Connecticut and New Jersey, it's a little bit different. I think in Connecticut, it's a little bit shorter period of time. COBRA notice would have to go out shortly if applicable. And then any PTO that has been accrued and unpaid would also have to be paid off at the time of that next scheduled pay date. So those are just some factors with respect to layoffs that you need to consider.
With respect to the... Yep. With respect to the WARN Act, which is the Worker Adjustment and Retraining Notification Act, I'm not going to spend a lot of time on it due to time constraints, but basically it's a federal statute that requires you as an employer to provide your employees 60 days advance written notice before you close a plant or conduct a mass layoff. If you don't satisfy those notice requirements, the financial penalties can be pretty hefty, including back pay and so on. The 60 days is the federal statute. Other states have their own individual WARN acts. New York, for example, it's a 90-day notice period. We're going to assume that one is a covered employer. That really depends in large part on the number of employees you have. And we'll assume for the sake of today's discussion that there has been a triggering event. In other words, there has been a mass layoff, which relies in large part on the number of employees you've laid off and what percentage those employees are in relation to your total number of employees. And so the issue then becomes with the impending implementation of the federal laws, for example, on April 1st, how can I possibly give, whether it's 60 days notice under the federal standard or 90-day notice under a particular state standard like New York, how can I possibly meet that requirement? I may only have a couple of days to make that determination. And fortunately, there are exceptions to the notice requirement that you have to substantiate and so on. And one of those exceptions is where there's an unforeseeable business circumstance. And with regard to that exception, that applies to mass layoffs, and it's caused by business circumstances not reasonably foreseeable when a 60-day notice under the federal standard should have been required. And an important factor that goes into, satisfying that threshold is that the circumstance is caused by some sudden, dramatic, or unexpected action or condition outside the employer's control. And the test that's used to assess whether or not less than the required notice will be acceptable is whether requires the employer, I should say, to exercise the same business judgment, the same reasonable business judgment as one would in predicting the demands of a particular market. No employer is required to predict general economic conditions down the line that may affect demand for its product or services. And we submit that the current climate, with the impact of the COVID-19 virus and the stay-at-home orders, federal, state, local, and so on, make a compelling argument that this particular unforeseeable business circumstance exception should apply and will apply. Again, you have to substantiate it and so on. There are certain facts that you'll have to be able to lay out, but we feel that, given the current climate and landscape, this exception would apply, and less than the 60 or 90-day notice would suffice. That said, you should try and give as much notice as possible. There are look-back periods. You don't want to get caught in a situation where you decide to refrain from predicting reasonably what you may end up doing down the line in the next month, 2 or 3. So you want to do that heavy number crunching analysis now. It's not easy, but it's recommended that you undertake that particular exercise in order to minimize the risk to your place of employment. Next slide.
Okay, so there are some practical considerations if you are considering reducing the pay or hours of your employees. We'll go through this one quickly. Also, in New York, an employee who is working less than 4 days and earns less than $504 per week can collect unemployment compensation to supplement their pay. Some considerations you want to think about if you're reducing salaries, whether or not someone's exempt and whether it may bring them below the exemption. You must pay an exempt employee during any work week that they did work the full pay. If you're going to reduce salaries and hours, you need to give a rate of pay change form 7 days before those changes go into effect. You need to ensure minimum wage requirements are still satisfied. You want to ensure compliance. If you have employment contracts or collective bargaining agreements, you're going to have additional considerations to determine whether or not you can actually reduce pay or hours, so you're going to want to consider that. As far as health insurance, which is obviously a big issue right now, all health insurance plans have eligibility requirements. You don't want your employees to fall below those requirements and potentially trigger COBRA when reducing hours or pay. However, we are being told by many health insurance companies that they are waiving eligibility requirements for some period of time. We've heard a month, 2 months, 3 months. So you will want to check with your specific plan administrator and benefits administrator. Another option out there is a shared work program for unemployment. New York State, you can apply as an employer to allow employees to share jobs so that they do continue to get some of their compensation, and then they can supplement through the unemployment insurance compensation. But you would need to apply as an employer to the state to get that plan authorized. Next slide.
All right. There have been some questions about difference between furlough and layoff. Marianne?
Okay, so I just want to briefly talk about furlough versus actual termination. It was until the recent guidance came out this past Friday, there was concern, well, if I don't fully terminate the employee, I just furlough them, meaning I just put them on a temporary, almost like leave status, okay, with still your employees, would I be subject to paying out these different benefits, including the federal paid sick leave and the expanded medical leave? And the guidance says no. If you decide to, instead of fully cutting ties with the employee, and sometimes it's a matter of semantics, want to know that they still have an employer, this might be a nicer way to go about it without risking also being subject to paying out under the federal Families First Coronavirus Response Act. Okay? And why it also could be potentially more suitable at while you're on a furlough, I don't have to automatically send out a COBRA notice and drop people off of the health care. Okay? Now, that doesn't mean, as Lauren mentioned, you still have to check with your healthcare providers. Most of them are dropping the eligibility requirement at least through May, the end of May, so they can stay on your benefits, right? So that's important. You don't have to empty out necessarily those PTO banks. Many people say, if I terminate you, I have to pay out accrued and unused time. If you're just on a furlough, keep those banks intact, which is a helpful tool. All right. So it is something you want to pay and consider, but it's a nice option instead of a full-on termination. Okay. The other thing, let me just mention, there were a couple of quick questions. I mean, we have dozens of questions that came in. We tried to answer them as we were going along, but somebody asked me about 1099. They're not covered as employees under these types of laws. Another asked about interns. Interns, if they're on your W-2 and they're paid interns, it would be covered. Again, you'll have to do the analysis of the part-time worker. So how many hours is that intern working on average? determine the amount of leave that they would get. A WARN question about, does it affect employers under 500? WARN does affect employers under 500. Federal WARN is 100. Most of the states' WARN thresholds are employers with 50 employees or more. So there are, WARN would apply if you're under 500 employees. And I'll answer one other question before I turn it over to my colleagues. Well, what if the employee is just there to come to work with benefits to people? And no, they wouldn't. They have to meet the criteria. Someone who just doesn't go to work because out of fear wouldn't be eligible for these benefits. However, if they tell you have a compromised immune system or a medical condition that may make them more susceptible and vulnerable, then you would have to engage in discussion about reasonable accommodations, both under the federal or state laws have those requirements. And it might be reasonable then to grant them the leave as a reasonable accommodation if they have a medical condition that warrants them to stay home during. I hope that answered a few of your questions. I don't know if the rest of my colleagues might want to jump into on a few others.
Thank you, Mary Ann. Go to the next slide, Andy, on the existing contracts.
Yeah, exactly. Next slide. All right. Are existing contracts, including employment contracts, enforceable if a party can't perform under the contract due to issues related to COVID-19? We've been fielding quite a number of questions about this particular issue the last several days, and we feel that the issue is going to only spike in terms of the intensity. And the answer is maybe, right? In terms of contracts may not be enforceable given governmental orders and related issues that cannot be anticipated or controlled and that are impairing or impeding the ability of parties to perform or are frustrating reasonable expectations of the parties when they entered into the contract. And there are different legal theories that may be available. You may be familiar with the term force majeure, which is a provision that may be contained in the contract between parties. But even in the absence of such contractual language, there may be escape theories that could be relied upon, whether it's frustration of purpose as a doctrine or the doctrine of impossibility or impracticability. If one of these theories applies, the contract would not be deemed terminated. Rather, the parties would simply be discharged from their obligations under the contract. But people should not feel that these particular legal theories are there for the asking. They require a high level of proof in order to satisfy them. But if the proof is there, they can serve as a basis to avoid obligations under a contract. But again, it's going to be a factual analysis, case-by-case situation. We've gotten a bunch of questions relating to this issue. For example, a medical practice that's barred from conducting elective procedures, is it still obligated to pay contracted clinicians or outside vendors? In the current climate, on notice of termination provisions in employment contracts enforceable? Maybe they are, maybe they're not. That's not a question of hedging. Rather, it's a simple reality of it depends upon the particular facts of that particular circumstance. Next slide.
Okay, and these are the slides Mary Ann spoke of earlier. We wanted to put up for you, and as Andy said, the PowerPoint will be made available at a later date for the people who have registered. These are just the definitions of who is a healthcare provider. So we do see we've run over our time by quite a bit already. So these, again, are the definitions. You'll have access to them. They were provided in guidance over the weekend by the U.S. Department of Labor. And if you can contact us if you'd like to get the link for that as well. And the next slide talks about the exclusions for small businesses. Those are the businesses under 50 employees, as they referenced. And you see there's 3 criteria that you could meet in order to be excluded. The takeaway here, though, with respect to this exemption that's possible is that it's due to school or place of child care closures. So it's not going to apply for the other provisions in terms of if an individual is sick or quarantined or you're taking care of someone who's sick or quarantined. It's specific to the school or place of care being closed. And that's a little bit different than the way the statute is technically worded, but that was direct guidance from the Department of Labor, and they've emphasized that in their follow-up commentary. And just to that latter point, we've seen that quite a bit, as Marianne had mentioned early on. We 15 days would have been April 2nd. They noted that it was April 1st. So we are all working within this construct where things are changing based upon the language. So we're not trying to punt these issues. It's just that we have to all stay very close to the information that's coming out. So, example, we saw a lot of questions come in today about the 100,000 threshold for the loan forgiveness and the PPP program. We're still waiting for further clarification on that. The way the statute is drafted, it could certainly be interpreted to mean that anybody making over $100,000 would not be included. However, we'd like to think that there's a possibility, at least, that the guidance comes out to say that only portions of salary above $100,000 would be excluded during any particular period of time. But right now, the way it's drafted, it seems to indicate that that would be excluded altogether. Up on our last slide, this is just our information for everyone to take down. We had hoped to be able to engage in a few more questions and answers. To the panel right now, I don't know if there are any other questions that you see that have come in that we would like to address, some more of the more common questions.
Yeah, this is Lauren. I just want to address, there was a question about the healthcare provider exemption. It is only for the federal law. There is no healthcare provider exemption under the New York State sick leave part.
And Lauren, I saw a question earlier on, maybe you can comment. What happens if a person was out already this week, for example, today, tomorrow, under New York State leave, and then tomorrow will be eligible for federal?
So if they're currently already eligible for state and they already asked the employer for it, then, you know, they will get the difference anyway. For instance, they may be eligible for 14, days under the state and the 80 hours under the federal. They're going to get the difference. So you do start collecting the state and then you just calculate the difference. You don't get to stack them both.
Okay.
I think we tried to get through as many questions as we could. I know people are dropping off now. It looks like our time has run short. So again, with that, we'll conclude. Please look for a follow-up email in terms of being able to get the slides and recording if that's possible. And anything, please contact your contact generally at Garfunkel or any of the four of us with any of these employment-related questions. And be on the lookout for additional alerts, guidance, and webinars that we will be scheduling in the near future. Thank you all very much for your time, and best of luck navigating these challenging times and decisions that you're faced with.
Thanks, everybody.
Bye.
Thank you.